The law matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. As we say, this program has been created to educate, inform, and help you with the law matters because the law matters. Understand the law better, and you're in a better position to decide how to protect yourself, your family, and your business. We continue to provide information and resources that'll help you decide whether you need or want to contact a lawyer. Perhaps we'll help you determine that you can actually handle some issues yourself. If you do need additional outside professional counsel, you'll be better prepared, and so will the professional you select. Our goal, of course, is to help you save time, save money, and achieve the best possible results. We continue to also welcome and thank David Bazar, Attorney Bazar, from the Bazar and Associates law firm in East Providence. He continues to provide insights and perspective on the various topics that we tackle week to week, so glad you're with us. So today, David, we want to talk about how judges are selected, the federal ones, the state ones, and Article 1 and Article 3, the Supreme Court, which is, of course, a very timely topic right now. What's the rule of law regarding having an independent judiciary, and what are some of the current challenges and threats to that, as it's talked about in the news often? And tied into that, should judges make the laws ever? Ever? Well, of course, David, we need a little history there, but apparently this has long been debated. Only when I started preparing for this did I realize that it sort of predates the Revolutionary War. Appointed, elected, appointed. Right. What's the status now? I know you're going to say it depends court to court, so how does it go?
Well, it depends court to court. So
and state to state?
And state to state. So you talked about a lot of different things in the opening there, so we'll try to break it down a little bit.
As you like. Federally,
there are two different types of judges that can be appointed, Article 1, Article 3, but in any event, what we're really looking for overall, if we want to start with that, is an independent judiciary, because that's what makes our system work on so many levels. And you talked about the rule of law, and the whole idea of an independent judiciary, it makes our economy work because people know they can enter into contracts that they can be enforced in a court of law without any influence of politics, or people who have greater bargaining power than the other might be able to get a better deal from a judge if there's some non-independence being exercised. It makes the legal system work criminally, that people are judged based on the facts and the law, and that the judge is not going to be biased by any outside thinking or pressure. And it's the independence of the judiciary that allows all of that to happen. So to break it down federally and state, and elected or not elected, really that's the selection process. And all the selection processes have political influence. You can't get that out of the system. It's what happens after the judges selected or elected that's important, and that the independence of the judiciary rests upon. I do tend to think that selected judges with lifetime appointments have more independence because they're not beholden on anybody to get reappointed or reelected. And so that's the system I prefer, and we can take it step by step and break it down now.
So that's a good thing to do. I can think of several issues that you raise, but let's go through how it's set up first so that you can more or less set the table for how this proceeds. Where do you want to begin, federal or state?
That's fine. Federal? So federal Article 3 judges, those are the judges that are lifetime appointments set up under Article 3 of the Constitution, which are generally speaking set up that there shall be one Supreme Court of the land, and then such inferior courts as Congress and so forth and so on set up from time to time. Article 1 is more executive and could be like a bankruptcy judge or administrative law judges, that type of thing.
Bankruptcy tax courts, if there are some?
Bankruptcy tax, administrative law judges who would hear perhaps Social Security appeals. There's a court, believe it or not, set up for claims against the government, for a claims court it's called. There's a vaccination judges that hear claims for people who receive vaccinations and are injured by those. So there's a lot of little known courts.
Military courts, I read?
Yeah, absolutely. But for the most part, when we think of federal judges, we think of Article III courts and judges, and we can start right at the top with the Supreme Court, because you probably picked this topic because there may be an opening and an appointment pending. So those appointments are selected by the president with the advice and consent and ratification of the Senate.
And that's the president first when it comes to Supreme Court. What happens with the appellate courts, the federal trial courts? Is it president first? Is it
Yep.
Senate? How does it work?
Yeah. So as you go down to Circuit Court of Appeals and then district courts, which are the trial courts, it is the Senate senator of, like, let's for instance say there's an opening in the U.S. District Court for the state of Rhode Island. The senior senator of the party of the president, theoretically, may have some input and advice to the president as to who to select. The president doesn't have to follow that. The president selects, and then it goes to the Senate Judiciary Committee to do their hearings, and then to the full Senate for a vote.
So they refer to, and I think you were referring to something that's the senatorial courtesy. You want to listen to the senator who, as you said, the senior, who might have some say in it. But of course, he would have a dog in the fight, but it would be the same dog in the same fight of the president who's going to be same party. It would have to be.
Usually. So it's usually Senator courtesy or Senate courtesy to the senator of the state where the court sits, even though it's a federal court. And again, the president, you're right, the president and the senator may have the same dog in the fight, and then it's up to the Senate to confirm.
And of course, while we may not have time to get into this completely today, the thought that there is supposed to be, according to the Constitution, a reasonable length of time during which the Congress will have to review who that nominee is.
Right.
What is reasonable
Yeah,
time, David?
there is no definition that anybody would ever agree on as to what that is. According to, I think it was Mitch McConnell when Obama made a selection. I don't remember how many. Yeah, if it was 2 years or a year and a half or whatever, that wasn't enough time for them to be able to act and confirm or deny, to have a hearing at all on the selection that Obama had made. They wanted to wait and see, maybe there would be a different president and pick somebody different. So I honestly think that is politics at its worst. At its worst. Yeah, at its worst.
If they're thinking 30, maybe 90, maybe it's 60 days might be reasonable. I think as of today's show that we're doing right now, 293 days they were saying. You can't go on 293 days, what they were looking at at one point.
Just as I think it is politically wrong, was politically wrong, for the Senate not to act on the Obama pick, it would be just as wrong for the Senate not to act on President Trump's pick at this point in time.
Well, tit for tat shouldn't have been written into the Constitution, right?
I don't remember seeing it.
So when it comes to both the federal Article 3 and Article 1, there are differences in their terms?
Yeah, so there's an appointment for a term in Article 1 court. Article 3 is an appointment for life. And that's really important. That's what I was talking about for the importance of the independent judiciary, for the judiciary to act free of political sway, to follow the rule of law, to apply law based on the facts and the law that they're looking at. In the Article 1 judges, it's, I think, a 10-year appointment, and it's generally speaking for courts that have a very specific purpose and usually wouldn't have much political influence or sway anyway.
So it wouldn't matter. So as I read about what the options are of how the states might choose a select or appointment, as you mentioned, merit selection, which of course seems to be a reasonable thing, but if you have a legislative committee, they might have a dog in the fight too. The D or the R after their names. Partisan elections, judges selected through partisan are voted by the electorate, run as part of a political party. And then there's something called nonpartisan election, meaning that they run for the judicial positions in states with nonpartisan elections. They don't put their name on the ballot of which party they belong, but they still would have a known affiliate if they've been around for a few decades, I would think.
Yeah. I'm not in favor of any of the systems that use any electoral process for picking a judge. Because remember, judges on the state level hear civil cases, they could hear criminal cases, they could be on the Supreme Court, depending on what level they're being selected or elected for. And they have to make tough decisions. And a lot of times they're not going to be popular decisions. So if you're elected, are you worried about how many people are going to think your decision, even though it's right, is wrong, and therefore not make the right decision? You make the wrong decision so that the electorate thinks it's right, and 52% of the folks are going to vote for you because you decided wrong. That is not a good system. I don't like that system. I think it's fraught with problems. People who have to appear in front of judges who are lawyers, are they going to contribute to a campaign for that judge? And if they contribute to the judge's campaign, do they get special treatment or at least the appearance of impropriety? There are just a whole host of reasons why that isn't the way we should select judges. Now, it doesn't take the politics out of it to have a selection process, even with the merit-based selection process that you talked about. In Rhode Island and Massachusetts, there is a committee that reviews judges to say whether they're qualified or not. In Rhode Island, it's an application process to the Judicial Nominating Commission, which will then select the applications to review and send 3 to 5 names to the governor for selection, then Senate confirmation. Now, that process has politics in it all the way through.
Sure.
People trying to lobby the commissioners on the Judicial Nominating Commission. Once they're selected onto that level, the governor, the Senate president, the Speaker of the House, I'm sure, all getting lobbied for people who are on the list. There is politics. But for the most part, I will say, having been through the process and seeing who has been selected from the process, politics aside, good judges are getting selected, and once they're selected, they're independent. They're appointed for life. They don't have to worry about reappointment or election. So now they're free to do what's right, free of politics.
So from your perspective, David, how do you respond to, along those same lines, those are crony deals based on whoever did some good service? How do you respond to that? You say you can't completely extricate the idea that there's some partisanship in there. How do you respond to that?
There is, and it's true that people who have had service in different areas of government maybe have a leg up in getting in on the list or selected by the governor or backed by the Senate president or the Speaker of the House. Those things happen. I do think, though, at a base level, the Judicial Nominating Committee will not send somebody through who isn't otherwise qualified. So I do think there is some weeding out. I'm sure that there have been people, I'm not 100% familiar with everyone who's ever applied, who have political connections and have served, who haven't made it onto a list from the Judicial Nominating Commission. So there is some weeding out that is done. And like I said, almost to 100%, for the most part, of the people I'm familiar with who have been selected by the governor, even if they've been selected over me, have been really good choices and have done really good jobs as judges on the bench.
So what does it take to merit the position? What are the qualifications? Does everyone have to be a judge, a lawyer? And what about magistrates? Maybe you should make that distinction as well.
And that's a whole different process, at least in Rhode Island.
Yep.
So let's start with, do you have to be a lawyer? Well, here's an interesting question. Do you have to be a lawyer to be a justice of the Supreme Court of the United States? And the answer is no.
Which may surprise.
Yeah, it may surprise many. That is not a requirement of a Supreme Court justice for the United States Supreme Court. There are requirements for judges in states and other levels to be lawyers. Even down to my municipal court judgeship in East Greenwich, they require a lawyer with at least 5 years' experience to be before you can be appointed or apply. So there are certain levels of judgeships that require the person applying to be a lawyer. There are different rules in different states and different positions. So,
and just to touch on briefly, magistrates?
So magistrates. In Rhode Island, there are magistrates authorized by statute for each court. Interestingly, we have one magistrate that's authorized through legislation that's called a general magistrate that has really many of the powers of a judge and can sit. The general magistrate sits in family court primarily. But when that position was created, the original statute allowed that magistrate to float from court to court as was necessary for the burden or caseload of each court. But for the most part, today, magistrates are picked in Rhode Island by the chief judge of the court in which they're going to sit with the advice and consent of the Senate. In other words, the Senate has to confirm whoever is being selected. The traffic tribunal is selected by the Chief Justice of the Supreme Court and then confirmed by the Senate.
So how is the chief judge selected? Does that vary, all right, state to state?
Well, state to state and court to court. Again, in Rhode Island, the Chief Justice of the Supreme Court is a JNC appointment or a nomination, 3 to 5 to the governor selection, and then the House and the Senate both weigh in on that confirmation. The other Chief Justices, it's the same as a justice, associate justice. It goes JNC, selection from the 3 to 5 list by the governor, and then only the Senate has to confirm.
So what role, if any, does the idea of seniority play in it? You're the oldest, you're next in. Is that true?
Not in state courts.
Okay.
In Rhode Island U.S. District Court, they rotate the Chief Justice, and the Chief Justice of the state court, the U.S. District Court, is an appointment for a term, and so I would assume generally the justice who hasn't been the Chief Justice with the longest appointment or term is the next one up, and then rotates out to a senior justice level, but still serves. Is there such a thing as the nomenclature of senior judge? And is that just based on how long he's been in? There is. Period? Yeah, as I was saying, U.S. District Court. Yes. In District of Rhode Island, there are senior judges who have been, they're U.S. District Court judges, and they're selected, in the process we described, and then they can have a term at Chief Justice of the district and then senior judge. Okay. The lower court judges, are they there for life? What about say even in your position, are you there until you decide not to be? So in Rhode Island, the state judges are appointed for life. In some judges in some other states, there is an age limit. It's an appointment for life. You don't have to be renewed or reappointed or elected, but after you reach a certain age, they roll you off the bench. Is that literally? Is that 70 or so? Is that? Depends on the state. It does depend on the state, because in several that I was reading, they did point to 70 as being the cutoff. That's young. That's young. It is young, and we just had a justice retire from the Rhode Island Superior Court. I think Justice Silverstein was 87 maybe, in his 80s for sure. And just a phenomenal justice. To this day, he's still sitting because his retirement hasn't started yet. He's a well-regarded, well-reasoned, very logical, applies the facts and the law as well as anybody. And, if he didn't want to retire, there's no reason for him at this point in time to have to retire. And where do other retired judges go? Do they go back and practice law? Do they sit in and fill in freelance? It sounds like a song. Where do the retired judges go? They can be called back. I see retired judges come back in family court and sit on cases where other judges may have a conflict of interest. They need somebody else to come in and hear the case for whatever reason or help out with calendars. They are allowed to come back and hear cases. And can they move from one court to the next? I mean, in other words, if someone were Chief Justice of the Rhode Island Supreme Court, is he likely to serve on a municipal court bench if he needed to? No, but if he was a retired Chief Justice of the Rhode Island Supreme Court, he often does and can serve as a mediator on cases.
If he's been trained as a mediator?
Yeah, there is training for mediation. The mediation rules aren't stringent as to what you have to do or who you have to be. You do not have to be a lawyer to be a mediator. You can be a retired judge. There is a lot of training that mediators should undergo, but not a requirement really. And I think it really will affect whether or not someone wants to hire you as to what your background is and what you've done.
What might a track be for someone who becomes a magistrate?
What might a trap be?
Tract of path of career.
Oh, a track? Well, again,
if not a lawyer.
Yeah, for a magistrate in Rhode Island, you're going to be a lawyer for the family court, superior court, district court, those appointments, traffic tribunal. And you're going to just go through the same process, really, as a judge goes through without having to go through the JNC.
Okay.
So, you're going to tell me they say politics plays a big part in that.
Yes, I could tell you that.
Yeah, and you will. And it can and it does. But again, once you're appointed, now magistrates are appointed for 10 years. So for the most part, they're independent once they get there. So politics doesn't play a big role in decision making, what they can do, but what they can hear is actually limited. They can't hear everything a judge can hear. So there is some limits on what they can do.
Good point of distinction. How are judgeships created? Who creates them?
Depends, federally or state. So
do both.
Very different. So the magistrates in Rhode Island were created by legislation signed by the governor, and it created how many magistrates a court could have. It's controlled, the budget's controlled really by the Speaker of the House and the House. So that's why they have some input into what gets done and appointed. But the number of justices and the courts themselves in states are created by state law or the Constitution of the state. And for instance, Rhode Island Family Court, the history of that is very interesting. Rhode Island Family Court was really a part of the Superior Court for a long time. In the 60s, the legislature created a separate family court and rolled that portion or division of Superior Court out of Superior Court into its own court, creating a statutory court known as the Family Court, which hears the domestic things, the juvenile issues, and DCYF cases now. So the jurisdiction of family court, unlike Superior Court, is very limited to the creating statute that set the court up in the first place in the jurisdiction that was conferred upon the court by the legislature at the time the court was created. The Supreme Court, obviously created by Constitution, United States Supreme Court, the Article 3 of the Constitution sets up that court and then gives the legislature the power to set up some inferior courts as it seems appropriate.
Appropriate or necessary.
Yep.
So the president is supposed to be picking the Supreme Court, filling the vacancy. They're supposed to have an eye to experience. Certainly they're going to have some attentiveness to political ideology. These days, there's interest in maybe their gender, their diversity. Makes sense because you want to have some balance, but at the state level, when those same issues are being considered, are those same issues being considered? Political ideology, gender, ethnic background?
Yes.
Does it play in?
Yes.
How does it play in?
And no.
Okay.
Yes. The JNC is set up on the notion that we should recruit and nominate qualified people of all different backgrounds. So diversity is an issue. And the governors in the past, and this governor currently, do make trying to appoint qualified people of diverse backgrounds an important notion. Politics, really, other than politics, but political ideology, not such a big issue on the state level, except maybe at the Supreme Court level to some degree, but at the state level, for the most part, you're not hearing cases that have a very big influence on political ideology. Whereas the national level, especially at the Supreme Court level, that has become way too big a piece of what we look at. But it's interesting, because of the rule of law that they're supposed to apply, and because of the independent nature of the judiciary once they get appointed, there have been many appointees who have surprised the presidents that have selected them.
Good point. Also, I want to ask, what is your thought about judges ending up making the law? Should that happen? Should that ever happen? I say quickly some cases, probably the most popular one is the Brown and Board of Ed. It's not decided at this level, and whatever else is kicked down the road, and suddenly a judge has to say that's just not right.
Right.
Where judges are not supposed to make law. That's the other side.
Right. And on state level, in the lower courts, as they might be called, Superior Court, District Court, Family Court, judges are always very careful to follow the law as it's been set out in case law by the Supreme Court and the statutes, and not to deviate from those, even when there are times when they say, I don't think this law is right, but it's up to the Supreme Court to change it, or the legislature. Sometimes the Supreme Court will say, it's up to the legislature to change this.
They want to bring it back down to the lower
right. But
level.
There are many things that are case law driven. And that is appropriate for the Supreme Court to review its own case law and determine whether or not it's correct or right and follow it. And if it comes to a point where the Supreme Court thinks, no, that is making law and it's a legislative function, that's all these checks and balance things that we've written into our Constitution, then they're supposed to defer to the legislation as it's passed by Congress.
So at this point, I'd ask, you champion the idea of an independent judiciary. I can't imagine anyone who would not. What is your thought or comment on the fact that courts are under pressure now, or they're in the hot seat, they're trying to defend themselves in many situations because they're getting a little bit of pressure from an administration? What do you say to that, David?
Yeah, so I actually recently heard Rod Rosenstein speak about the rule of law and the Department of Justice having to be free of political influence, and the judiciary having to be free of political influence. And he talked about lawyers having to be beacons for society to understand the rule of law and what it is. And he gave a little story about 3 stonecutters. And they asked the first stonecutter, tell us about your job. And he said, I make a living. And they asked the second stonecutter, what do you do? And he said, I cut stone. And then they asked the third stonecutter, and his face lit up, and he said, I cut stones that build cathedrals. And his point was, lawyers make a living, but that's not what they do. They handle individual cases and litigation, and that's important, but that's not what they do. It's the protection of the rule of law and how our judicial system works and how they do their part to protect it so that it is free from political influence and that decisions are made solely based on the facts and the law as it's supposed to be applied. And if a judge applies the law, you may not necessarily agree with how he did it, but you respect how he did it because you know he followed what he thought the law was.
Of course, that's being challenged in many situations now. Whether it's travel bans or separating families and children, there certainly is an awful lot of...
Right, and that's his point is the judiciary needs to apply the law whether or not there's influence from politics, free of that.
Thank you, David. We certainly have covered many topics, federal and state level judges. We hope that this has been helpful to you and given you some greater insight. We thank you for tuning in to The Law Matters. We hope you will continue to, because the law matters to you.